Divorcing a military spouse can involve some unique considerations compared to a civilian divorce. These can include special rules about military benefits, jurisdiction, custody arrangements, and the military's involvement in the process. Here is a detailed description of the steps and typical timeframes involved when divorcing a military spouse. Step 1. Filing for divorce. What happens? The process starts when one spouse, the petitioner, files for divorce with the appropriate court. The petitioner will submit a divorce petition, or complaint, which outlines the grounds for the divorce, details about any children, and requests regarding asset division, spousal support, custody, and visitation. In some cases, if the military spouse is stationed out of state or overseas, special provisions may apply regarding jurisdiction. Time frame? Filing for divorce can take anywhere from a few days to a few weeks, depending on how quickly you prepare the paperwork. The time it takes to get the petition into the correct court may vary based on the location of both parties. Step 2. Serving the divorce papers. What happens? After filing, the spouse, the respondent, must be served with the divorce papers, formally notifying them that the divorce proceedings have begun. If the military spouse is stationed far away or overseas, special rules exist for serving military personnel. The Soldiers and Sailors Civil Relief Act, or SSGRA, protects active duty service members from legal proceedings that could interfere with their service, so you may need to follow specific steps to serve them, including serving through their military base or unit. Time frame. This can typically take a few days to a couple of weeks, depending on the service member's location and whether you can personally serve them or need to use military channels. Step 3. Responding to the divorce petition. What happens? After being served with the divorce petition, your spouse has a set time, usually 30 days, to file a response. If they agree with the terms of the divorce, the process may move forward more smoothly. If they contest it, this can lead to a more complex process. A military spouse may request a delay in proceedings under the Service Members Civil Relief Act, or SCRA, if they are on active duty. The court may delay the divorce by up to 90 days to accommodate their military service obligations. If the military spouse is deployed, the court may also delay proceedings until they return. Alternatively, the service member may agree to proceed without attending hearings or appear by telephone or video. Time frame. Typically 30 days to respond, although if a service member is deployed or on active duty, the court may delay the timeline as requested under the SCRA. Step 4. Temporary orders if necessary. What happens? If there are immediate issues regarding child custody, support, alimony, or military benefits, either party can request temporary orders from the court while the divorce is ongoing. This helps address issues such as child support or spousal support while the case is being resolved. For military families, temporary orders can include child support, spousal support, and decisions about the use of military benefits like healthcare or housing. Time frame. A motion for temporary orders can typically be heard within 2 to 4 weeks, depending on the court's schedule and urgency. Step 5. Discovery and negotiation. What happens? Discovery is the process of gathering information, financial documents, and other necessary materials to help resolve issues like property division, support, and custody. This includes exchanging financial records, military pension details, and any other relevant documents. Negotiations or mediation may take place to try and resolve outstanding issues outside of court. Many military couples go through mediation to reach an agreement on matters like child custody, visitation, and division of military benefits. Time-frame discovery typically takes 1 to 3 months, depending on the complexity of the case and cooperation between both parties. Mediation or settlement negotiations may take a few weeks to a few months. Step 6. Division of military benefits and property. What happens? One of the unique aspects of a divorce involving a military spouse is the division of military retirement benefits. If the military spouse has served for at least 10 years and has been married to the civilian spouse for 10 years, known as the 10-10 rule, the non-military spouse may be entitled to a share of the military pension. This can be divided as a direct payment to the spouse or through a court order known as a Qualified Domestic Relations Order, or QDRO. In addition to the military pension, military benefits such as TRICARE health insurance, base housing, and life insurance may also be a part of the divorce negotiations. The division of property, including the military pension, can be complex, and an attorney familiar with military divorce law is crucial for ensuring that the non-military spouse receives their fair share. Time frame. This step often occurs throughout the divorce process, but it can take several months to finalize, depending on how complex the division of military benefits is. Step 7. Mediation or settlement conference if applicable. So what happens here is, if the couple cannot agree on all terms, the court may require a mediation or settlement conference before proceeding to trial. The goal of mediation is to help both parties reach an agreement on unresolved issues, including custody, child support, and the division of military benefits. Now, regarding the time frame, mediation typically occurs after discovery and may take several weeks to arrange, depending on court availability and both parties' schedules. Step 8. Finalizing the divorce. Once both parties have agreed to terms, or if the court has made decisions in a contested case, the final judgment of divorce is issued. This includes all the court's orders on child custody, visitation, support, property division, and military benefits. The final order will specify the division of military pension benefits, the distribution of any other assets, and the custody arrangement for children. The finalization of the divorce can take anywhere from 1 to 3 months, depending on the complexity of the case and whether there were contested issues that needed to be resolved. Step 9. Post-divorce modifications, if necessary. After the divorce is finalized, there may be a need for modifications to the original divorce decree. This could include changes to child custody, child support, or spousal support if there are significant life changes like a military reassignment or change in income. Post-divorce modifications can happen any time after the final divorce decree, but these motions typically take a few months to process, depending on court schedules and the complexity of the changes being requested. Estimated timeline for divorce. Involving a military spouse. An uncontested divorce can take about 3 to 6 months if both parties agree to terms, including military benefits and custody. A contested divorce, on the other hand, can take 6 to 12 months or more if there are disputes over military pension division, custody, or other complex issues. Additional considerations. Military retirement can add complexity to the divorce process. It's important to ensure that any divorce settlement properly accounts for military retirement benefits, which may require specialized legal advice or a military pension expert. Active duty considerations are also important. If the service member is deployed or stationed overseas, certain steps may be delayed or adjusted to accommodate the deployment, particularly in regards to court appearances and serving the papers. Overall, a military divorce can take anywhere from a few months to over a year, depending on the complexity of the case, the involvement of military benefits, and whether the divorce is contested or uncontested. It's crucial to work with an attorney experienced in military divorce laws to ensure your rights are protected throughout the process.